Leah, can you hear? I can't hear you.
I was on mute.
Well, I'm probably supposed to be. I don't know. Should I upload that picture of you with 1,000 emails around so as Exhibit A? The fact
so you know, right now, everybody
working your due diligence.
Yes, there's 47 participants watching. So if I will talk to you later.
All right.
I'm going to mute.
All right.
But you can go out and take pictures of all those emails.
I already did. I don't know how to upload them into this thing though. I got tons of emails. You sitting there with your not knee high at least.
We've gone through
magistrates' piles.
We've gone through 5 reams of paper.
Jesus,
that's
2,500 emails. Oh my gosh.
Okay.
Hello, Council. It's Amanda DeGainer, Court Clerk. We will be getting started here in just a moment. Should anybody else be joining us that I might be missing in our attendees?
Madam Court Clerk, yes, this is Robert Whitney. Can you hear me?
Yes, I can.
Can everybody hear me?
Yes.
We're expecting, it looks like they've been, I was going to say they've joined. I was going to say the Attorney Ott and Attorney Jordan and Administrator Gow were having a little bit of trouble joining the meeting, but I can see them on screen. So it looks like they've been successful at.
Okay, thank you.
Your screen isn't on, Bob.
Oh boy. Okay, let me see if I can.
The button on the left down.
There we go. I think I hit it. How about now?
Good.
There you go. Thank you.
Thanks, everyone.
All right, good afternoon, everyone. We are on the record in the case of Amethyst Payne and others versus State of Nevada, XREL Nevada Department of Employment, Training and Rehabilitation, which we did yesterday and will continue to refer to as Detr. I'm Judge Breslow. I'm physically located in Washoe County. We are proceeding under Supreme Court Rule Subpart 9, which allows these hearings to be conducted through simultaneous audiovisual transmission, available in multiple avenues for people who would like to attend, including coming on as participants in the Zoom webinar platform, going to the court's YouTube channel or other media outlets that the court is aware will be broadcasting live stream this hearing. In addition to Nevada Supreme Court Rule Subpart 9, various administrative orders of the Second Judicial District Court and the Nevada Supreme Court have allowed hearings like this to occur other than in person through virtual means. At this time, I ask the court's staff to please identify themselves and as well confirm where they are connecting from, starting with the court clerk, Ms. DeGainer.
Mr. Honor, Court Clerk Amanda DeGainer, calling from Washoe County, Nevada.
Thank you very much. Ms. Zinn.
Isolde Zinn, Washoe County, Nevada.
Thank you very much. Next, I ask counsel for plaintiff, starting with Ms. Jones and then Mr. Thierman, to please identify themselves and identify as well where they're calling in from.
Leah Jones for plaintiffs, calling from Washoe County, Nevada.
Thank you very much. Mr. Thierman. You're on mute, sir.
Mark Thierman, also in Washoe County for plaintiffs.
Thank you very much. Counsel for the state of Nevada, starting with Mr. Whitney.
Good afternoon, everyone. Robert Whitney calling in from North Las Vegas, Nevada.
Thank you very much. And then I understand as well, you have attending and may participate in this hearing Attorneys Ott and Jordan, and Administrator Ga. If that's you there in the conference room, it's a little hard to see, but would you please identify yourselves, starting with Counsel Ott? Are you on this call?
Yes, Your Honor. Greg Ott, calling from Carson City, Nevada.
Okay, thank you.
Troy
And is it,
Jordan,
go ahead.
sorry, Your Honor. Troy Jordan, Carson City, Nevada.
Thank you very much. And Madam Administrator, are you there as well?
Yes, sir. Kimberly Ga, Carson City, Nevada.
All right, thank you very much. And then the special master appointed by the court yesterday, Mr. Guanasso, would you please identify yourself and what county you're reaching us from?
Yes, Jason Guanasso here, appearing from Washoe County, Nevada.
All right, thank you very much. All right, this is a follow-up to yesterday's comprehensive hearing on the motion for order to show cause, why the writ of mandamus should not issue. In the interim, the court has reviewed a few additional items. I want to bring those to your attention. First, the court acknowledges and thanks Mr. Guanasso for complying with the court's request to file an affidavit consistent with Nevada Code of Judicial Conduct Rule 2.11, identifying that he is conflict-free and willing to serve. I appreciated the references to professional interactions that Mr. Guanasso has had in the past with Mr. Thierman and also with Messrs. Jordan and Ott, none of which, when the court reviewed, appeared to in any way disqualify Mr. Guanasso from the ability to assist and be fair and impartial in his doing so. I noted as well Mr. Guanasso's statement that he had conferred with counsel for both sides and was sharing with the court that they informed him that they also agreed that he was not in any way conflicted out of this position. Since we're all here, and just to put it on the record, I'll ask first plaintiff's counsel, Mr. Thierman and Ms. Jones, is that still your position that Mr. Guanasso has nothing in his professional background that would make him ineligible or conflict him out from serving this role?
That is correct, Your Honor. Mark
Thank-
Thierman for plaintiff.
Thank you very much. And then who would like to address that as on behalf of defense counsel?
Your Honor, this is Greg Ott in Carson City. I'll address that and start off by saying the ultimate answer to the question is no, that we believe that there's no reason to object to Mr. Guanasso. I do believe that there's an amended affidavit that either has been filed or will be filed that addresses an issue that we spoke with Mr. Guanasso about shortly before this hearing. But having that conversation and appreciate his willingness to connect on a short time, but having had that conversation, we're comfortable with his appointment.
All right, thank you. So who will be filing the amended affidavit as you understand it, Mr. Ott? Will that be Mr. Guanasso or will that be the state?
I believe it's Mr. Guanasso.
All right, Mr. Guanasso, anything that you've learned since the filing of your affidavit give you pause or in any way change your thinking on your ability to serve?
No, thank you, Your Honor. Jason Guanasso for the record. No, I provided an addendum to my affidavit about 10 minutes ago explaining that there was a tweet that was brought to my attention from April 29th of this year. And if Your Honor would like me to read it, I had tweeted out that this was an example of the frustration many people are feeling as a result of state unemployment being overwhelmed and dysfunctional. I get these types of messages every day from people in my community, but I don't know how to help them. Anyone know how to help them? And the example I was referencing was a text message that's like several I was getting at the time from an individual who said, that they are trying to get a hold of unemployment, that they'd made hundreds of calls to that effect and couldn't get any relief. As a result of sending that tweet out, I did get help and assistance from various people who had knowledge about how to assist people with these kinds of questions. I was able to successfully help them. And I included that in my affidavit and explained that to Detr. And as you heard from them, they don't have any issues with my impartiality in this matter. So I think I can proceed forward and do the work that you've asked me to do.
All right, thank you. Well, two comments. First of all, thank you for sharing that and communicating, especially with the state. And apparently the state, notwithstanding that, maintains its position that they are comfortable with having you serve in that role. So again, Mr. Rod, is that still the state's position?
It is.
All right, thank you. And then second comment is, if everyone on this Zoom call had to step aside because they were the recipients of attempted contacts to identify positions of people in this community, there would be nobody left other than possibly the court certified shorthand reporter, Ms. Zinn. So, the key for all of us is to maintain, for the court's purposes, impartiality and politely, not respond, not even review direct communications with the court. That's inappropriate. With respect to the master, at this point, Mr. Guanasso, you're similarly situated that you won't respond directly to any communications. And I strongly suggest you put them in a folder for reviewing later, if ever, but not while you're the master. And then for counsel for plaintiffs, I'm sure they have more than enough, but they probably keep coming in, and the state as well. So I appreciate you sharing that, but we're going to go forward. Let's get to work. The court is working on an order consistent with Nevada Rule of Civil Procedure 53, which, if I'm able to, get it together, will come out tomorrow afternoon. I did have a lengthy criminal justice calendar this morning, which took a little more time than I anticipated, but I'm working on it diligently to identify what the court believes the areas are that Mr. Guanasso should be working on. Once that order is filed, if either side feels strongly or wishes to object, please put in writing your concerns or objections, and we'll have a hearing about it as quickly as we can. But the goal, of course, remains the same as of yesterday when we met, and namely is to have Mr. Guanasso get in there and collaborate with both sides on how he can best prepare a report that identifies facts that the court can utilize in determining whether a writ should issue, to assist the court in identifying possible bottlenecks, possible inconsistencies, any, inefficiencies in the system that might be subject to review and consideration by Detr, to show the good faith efforts that Detr maintains that it is undertaking to respond to all these claims for benefits, and this is something a little bit new because I wasn't fully apprised of this at the time of the hearing yesterday because it had come in a little bit late in the game. I just had generally had the opportunity to review it more thoroughly this morning. But Director Gah's declaration and the exhibits attached, one of which was one of the exhibits from the hearing yesterday, is to ask Mr. Guanasso to double check the factual allegations embedded in Ms. Gah's declaration, not to challenge her veracity or truthfulness, but to make sure that what she said is supported by information that is that the court will find reliable and will be able to in part base a decision on. Also to identify ways to make the application process more user-friendly, trying to make sure there is clarity in the manner in which people are advised of the status of their claim, that the requirement to file weekly is not just on the form, but in big bold somewhere near the top, so people are not confused or in any way unable to comprehend that. And then, of course, one of the biggest issues that was raised yesterday, and it was in the briefing and it was spelled out in greater detail, was whether having a balance in a UI account is a preclusion for people to access funds made available by the recent enabling legislation. And if so, what is the best way to handle that issue? Because that was the biggest line item, as the court recalls from yesterday, some 43,000 people. And I know that, as Mr. Thierman said, if that problem could be drilled down, that would address a high majority of the people that right now are in a bit of limbo. And so I want to know from Mr. Guanasso, after collaborating with both sides, how best that might be addressed, and also what impact does that have on the court's ultimate determination whether a writ should issue. So those are just some of the things that you should expect to see in the court's order, hopefully tomorrow, Friday at the latest. Starting first with Mr. Guanasso. Based on what the court just said, based on what you heard yesterday, based on anything you've thought on or spoken with these people about in the last 24 hours, how do you respond to what the court just said? And if I'm missing things, what else should be in the order, please?
Yes, Your Honor. Thank you, Jason Guanasso, for the record. So I was able to spend about an hour with each party yesterday, going over what occurred at the hearing and some of the major questions. And I've laid out what I think would help the court in reaching a decision about what's been presented to the court. And one of the issues we identified was being able to really explain what the unemployment system is in Nevada. That is, what was it before COVID-19? What is it after? Being able to look at the benefits that were talked about yesterday in greater detail so that the court can understand those eligibility requirements that Detr's looking at. And then putting that system, once it's laid out clearly how that system is set up, looking specifically at claims that were accepted and the date that they were applied for, the date that they the eligibility was determined, the date that money was received. And within that group of accepted claims, it was brought to my attention yesterday that there were subcategories in there that had to do with people who were determined eligible but aren't getting paid, even though they have an accepted claim. That is, they're getting a debit card, but no money's on that card. So looking into that issue for the court. And then also people that initially received benefits, but then those benefits stopped for some reason. So that's one category or one data set. The other data set we're looking at were the denials, specifically understanding when the application was made, when the denial was issued, and what were the reasons for the denial. And we're trying to put together a comprehensive list of why denials were made and put them into a data set so that the court can understand the reasons for denial and if there are easy fixes to those denials to identify those. But if those denials need to go through adjudication, understanding the infrastructure that's available to address adjudication, because that came up yesterday as well. And then finally, there's this middle set that was talked about quite a bit yesterday, Your Honor, and that was applications that have not been decided. They're in limbo. And putting those into a data set, understanding when the application was made, and where and what's the reason why there hasn't been a determination. Your Honor heard yesterday that one of those reasons may be for fraud. So we're going to flag all of the ones in that data set that were caused by fraud and be able to understand what that process is like. There may be user error, so people not filling in the right boxes. We're going to identify all those for Your Honor. And then the last piece to this is just taking all of that, those findings, and then helping Your Honor understand the human experience. I know since yesterday, Your Honor, and the time that you appointed me, I've received hundreds of emails of people telling their story, very similar to what we've seen in the declarations provided by plaintiffs. Plaintiffs' counsel has received over 5,000 emails that they're going to share with me about their experiences with the system. So I'm going to try to match up those human experiences for Your Honor with the data and the explanation of the system and where it all fits, and compare it to some of the testimony that you heard yesterday to try to give you a comprehensive picture of what's occurring and maybe some recommendations that the parties may even agree to how to address what the court called yesterday bottlenecks and inconsistencies.
Okay, let me respond. Thank you. That was very helpful, and we'll talk with counsel here in just a moment. But I want to clarify what I said earlier. You know, if people reach out to you, Mr. Guanasso, and ask you to do something for them or take a position or advocate, those are the kind of communications that you need to, of course, ignore and can act upon. If it's determined that communications from people as to their experience with trying to navigate the system, the responses that they've received, the efforts they've made to correct errors brought to their attention, their inability to obtain benefits from cards that ought to have money or credit on them, things like that. Well, that's going to be part of what you can take a random sampling looking at and see if that there are issues and approaches that can be used to address them. Having said that, Mr. Thierman, based on what the court said yesterday, the court said initially this afternoon and what Mr. Guanasso said, are there other issues that the plaintiff would suggest should be in the court's order at this time? And Mr. Thierman, you also are still on mute.
Thank you. I'm trying to keep my office noise out of the court's.
Thank you.
Anyway, after the hearing, I received maybe a couple hundred emails correcting some of the things I said in court, and I wanted to put that on the record just so it's there. I don't know if it actually makes a difference, but the category of weekly filed, I am told repeatedly that the computer would not allow people to file weekly once their claim was determined under review or had issues. So that may also account for a subgroup of the weekly filed. So to the extent I conceded that those who do not file weekly are not entitled or should have to refile, that would not include the people who were prevented from filing because they were basically locked out of the system.
Okay.
The second issue I think that I heard yesterday, which was actually a surprise, but I didn't raise it, was the 30 adjudicators versus the 8 the governor had said the day before or 2 days before. I was subsequently told that the 30 have to report to the 8. I don't think it matters. I'm only concerned with the result, not the process in terms of the number of people, the claims getting made. But for whatever reason, my people are very upset about the accuracy of the statement, and maybe the administrator wants to explain it one more time. It doesn't matter to me. As long as the claims are processed, I don't care if it's done in China or India or wherever.
What we saw, let me interrupt. We saw from Administrator Ga's declaration that you don't just start on day one as an adjudicator.
Yes.
You really need to work your way up. You start as a level 1, which is you're just starting to understand what the task is too. You know, you're like kind of like a sophomore in high school. You feel like you know the ropes, but you really think you know more than you do. And then 3, then you've got to be right at the top of the game to be an adjudicator. So the fact that they're apparently bringing more people on or moving people up on the totem pole to that level and having oversight is a positive. The question is, how long, how quickly, how many weeks, days, months will this take? So that's
I heard it was 6 months before someone actually got to a level of actually making a meaningful permanent decision, and that even the 8 adjudicators don't seem to be able to override the computer sometimes. But again, I don't know if it matters from my point of view, and maybe not from the court's point of view, as long as the special master deals with it, because you're interested and I'm interested in getting claims processed. And the in-between part, I guess, is Detr's problem.
Well, let me explain my role again.
Okay.
Because right now, I'm wearing a couple hats. The first hat is I need to decide whether a writ should issue based on the law as it exists, or issuing a writ directing another branch of government to do its job or do something differently. Or I interpret the law differently than they're interpreting it, and I outvote them 1-to-1. And until a higher court tells me I'm wrong, they need to interpret it the way the district judge said, and that's how they have to do it. But to make that decision, I need more information as to what's happening now. And that's where Mr. Guanasso comes in. Now, the second hat is if Mr. Guanasso's report leads to identifying inefficiencies, redundancies, streamlining, better approaches, then, God bless him. And if everyone agrees that that will unclog the system and move claims through more quickly, and I'm not going to use the word fairly because that implies that people are being treated unfairly at this point. I haven't made that conclusion, and that's not on the table at this moment. But if that can happen, then we can see if whether the court needs to rule on the writ application next week or it does not. Because if the genesis of this is, judge, do something because the claims aren't being moved through and it's unfair and the law is being construed wrong, I'll make a decision. But if it's, let's find ways to process more quickly, and that's really, we've gotten their attention, that's the second hat the court's wearing. So with that, let me hear at this point from Mr. Whitney. I'll come back to you in a minute, Mr. Thurman. Mr. Whitney, anything else that you like in the court's order? Anything you've heard that you don't want in the court to address for Mr. Guanasso? Anything that's changed your thinking on it since yesterday? Please tell me.
Your Honor,
Thank you, Your Honor.
this is Greg Ott. I'll take that if you don't mind.
Well, isn't Mr. Whitney your supervisor? I'm not sure how that works.
Your Honor, it's the other way around, actually. Mr. Ott is my supervisor.
Beg your pardon, Mr. Ott. I didn't mean to step on your toes here. Go ahead, Mr. Ott.
I might be happy for the demotion, Your Honor. Just wanted to phrase a couple things. First of all, I want to make it clear that we're supportive of the appointment of Mr. Guanasso, and we look forward to working with him. With regard to the different hats that the court is wearing, I'm happy to hear that there is the recognition that we are still in the context of a writ hearing, and that is the procedural posture. I understand that some of the charges that Mr. Guanasso may be examining fall maybe outside of what would be within the parameters of that writ. And so we would reserve our right to object if the court went beyond that on the proper grounds. But that is not to say that we don't want to work with him. We look forward to working with him, to fully fulfill his charge.
Right.
With regard to the other items that might be worth including in the order, a couple of things that I think could be important. One is we talked a little bit about the fraudulent issues. Some of those, in order for Mr. Guanasso to fully access the information that he needs, I think it might be worth giving him the ability to accept documents under seal so that documents are not necessarily provided to the public. If that's something that he feels is appropriate, given the circumstances of the documents.
Your Honor, we would stipulate to the standard protective order we always use that counsel only and obviously the court.
All right, that
That
sounds
we experts, then we'll call them in and swear them to the secrecy also.
okay. And that sounds like a good idea because there's going to be a lot of sensitive information that Mr. Guanasso, personal information, people's address, name, earnings, working history, whatever that you would be looking at, Mr. Ott, Mr. Guanasso will be looking at some of that same information. And so it's likely the court would order that type of information be kept confidential, used for purposes of this case only, and in Mr. Guanasso's role as a master assisting the court. So that makes a lot of sense. What else, Mr. Ott?
So that brings up another interesting point that I wanted to talk about with respect to the confidentiality of individual applicants. NRS 612-265, I believe, addresses that. I think the court could conclude, and maybe Mr. Thierman would stipulate that the named parties have waived confidentiality, so their information could be shared with Mr. Guanasso. But as to other unnamed parties who may have submitted personal confidential information to Detr, I'm not sure that information can be shared, and I think it probably can't under the statute. So I think that to the extent that personal information of non-parties is something that Mr. Guanasso needs, I don't think we'll be able to share that. We can certainly work to do so in a de-identified way and work with him to get as many bulk reports as possible. But I want to be cognizant of the personal information of non-parties who I don't think we can violate their confidentiality.
Well, one way to address that is, we black out their name, right? And we're just looking at John Doe 1, Jane Doe 1, John Doe 2. I mean, for examples of what people are submitting and the responses they're getting. But Mr. Guanasso, what do you think about that?
Yes, Your Honor, I agree. We can either, if we're looking at specific applications for one reason or another, we can block out names and personal identifying information. When we were brainstorming this issue yesterday during our call, one of the things we had discussed was desegregate or getting rid of the information about the individual, that is the name or social security number, and just giving them a unique number that we could refer to if we needed to identify that person as a real person. So let's say we have 100,000 people in a data set of denied claims. We would have unique numbers for each of those people with the date they applied, the date the denial was issued, the reason for denial, and if the case is in adjudication, identifying what stage of adjudication it's in. If it's not, the reason why it's not in adjudication, maybe it wasn't appealed or there was some resolution. So that was just a sampling of some of the things we were talking about in terms of how to deal with confidential information, in addition to taking information under seal so that I could, look at, things that may be pertinent.
All right, that makes sense to the court. Mr. Thierman, what do you think about that?
I agree completely. I don't know if the statute would prevent the court from having access to the personal information.
Well, and then
I don't
as
really,
the
I
special
don't really
masters,
want it. I do a lot of class actions. We usually use last four social security number if we can get them. It's already assigned, but whatever system works.
okay. Mr. Ott, the way Mr. Guanasso just explained it seems to make sense to the court. That way, if we are referring to a person, we don't call her by name, address, or social security number. We say applicant number 7011, and we all can refer to that, or applicant 1403. But we want to protect confidentiality, but make sure that the data, the information, can be used to assist Mr. Guanasso in his investigation and some of the conclusions that we anticipate being in his report.
Yes, Your Honor, and we agree with that, and we're happy to try to work with the data to get him the information he needs. There is a practical component of working with data sets that large and being able to do the programming to get the information in a timely manner to him. So I'm not sure exactly if the reports that he will need, how long it will take to produce those. We'll certainly do whatever we can to get him all the information he can. I want to flag that issue for the court because these are extremely large data sets that we'd have to arrange in some specific detail, maybe to be of the use that he wants them.
That's fair. Do what you can as quickly as you can do it to assist Mr. Guanasso. Mr. Guanasso, let's work with the information that you'll have access to. And I'm still going to shoot for a report, by Wednesday and a hearing on Thursday of next week.
Thank you, Your Honor. If it helps, Detr, I do have access to IT professionals in my law firm that could help with that. If it was a matter of just turning over raw data to us that we could then sort, then we're happy to do that. But there may be some problems with that too. I don't know. We'll figure those details out. And Your Honor, if we run into problems because it's going to take a little bit of additional time to sort through that information and get it into a format that works for the court, we'll let you know as soon as possible.
All right. Well, I have two comments on that. First, let's try to keep the deadlines that were established yesterday. I really, really, really want to make a decision on this case by a week from tomorrow. But that's the goal. If it needs to be pushed back a day or 2 business days, the world doesn't end. But the people that are invested in the decision here are anxious. The court would like to get a decision out as promptly as it can. Second comment is I will make myself available to resolve and assist with discussions to move this along. In other words, you'll have a concierge judge here, that I'll make myself available. I have other matters that need the court's attention, obviously, but I will do my best to be available on any day with a couple hours notice for a quick call. So know that. Right now, though, for the rest of this week, for tomorrow and Friday, my judicial assistant remains on holiday this week. So if you need to reach me, do it please through the court's clerk, Ms. DeGainer. Okay, what else, Mr. Ott? Are there any issues with the order as the court anticipates it that you want to bring to the court's attention?
So one final issue, before I get to that, just want to make it clear that we were not asking for those deadlines to be pushed out. I was just flagging those issues for the court to let you know that even though we're trying to cooperate, there are logistical issues.
Understood.
So the last issue, I think I understand the special master's role is to be largely fact-finding. Just wanted to understand if he will also be making legal recommendations that the court will take under advisement, or whether it's purely fact-finding.
It's fact-finding. When I say he's to render conclusions, it's not, Judge, here's what you should do. It's, here's what I've reviewed on the data. One issue I've recognized that might be of assistance. One issue, how the approach could change. I mean, something like that might be of assistance, but mostly data, facts, inefficiencies, user-friendly, interface problems, percentages. Take a look at Administrator Gah's declaration. Try to update the information as of early to next week or middle of next week, and how go the rates and the percentages. I'll give you an example. Administrator Gah noted that the issues with potentially fraudulent applicants are much more serious, than you would otherwise expect, or that otherwise in normal times they're faced with. So hopefully Mr. Guanasso can drill down a little bit more on that and provide the court additional information. So to answer your question, Mr. Ott, fact-based, no recommendations as to how the court should apply the law to the facts, but with an asterisk that if he notes inefficiencies or approaches, it would sure help the court to understand those better for the purposes of the second hat that the court mentioned it really is wearing here, which is if there's a way to move this case off of the issue a writ or not track into, Judge, we think we have a system that let's put this on pause, a court order for 20 days and see if this new approach, the new people, the inefficiencies or the redundancies or the interface is being improved, that might address many, if not most, of the issues. And let's take another look at it at the end of July. The court wouldn't be adverse to that. But if we need to make a decision, I'm prepared to make one on Thursday of next week. All right, Mr. Thierman, other thoughts?
Yes, two things, Your Honor. First, I wasn't aware you hadn't read Ms. Gah's file declaration. I thought I read it right before the court hearing, and I was talking at the last hearing about her admission that they had been doing it wrong to those people who had accepted or they had issued eligibility decisions, and that I was expecting and yet have not yet, as of today, received any notice that these people have in fact been paid. There's some mythical, magical button that somebody forgot to press on those people, and I'd love to hear that 12,000 or so of these eligible people have been paid, and I could take them out of the piles that Ms. Jones and I have been sorting of emails. The second thing is you talk about, you mentioned the UI account problem, that the unemployment insurance account. There seems to be, I'm now getting denial letters, recent, as of yesterday, copies of denial letters for the UI account. I'm sorry, based on the fact, for the BUA account, based on the fact there's a UI account. And instead of simply automatically applying to the UI, because they say they're eligible, and giving them the UI money, we get this misstep, this extra, it's balls in your court. Mother, may I please move it back? And if you don't, we're not going to pay you. I don't think that's consistent with the statute. I think DETR is, once the application is made, it is made for all programs and all, where again, the allocation is up to DETR. So therefore, once an application is made, if DETR determines that PUA cannot be paid because of UI, maybe in the same letter that they say DUI, a PUI cannot be paid, they ought to say, because of UI, they ought to say, and by the way, here's your UI payment. Or we've already started evaluating the UI situation. But of course, if they're just evaluating the UI situation, then the denial of the PUA would be premature.
All right, well, let me respond to that, because, you know, this is the kind of argument from yesterday's hearing, as opposed to what the role of the special master is going to be. But so I'm not going to let that go unresponded to, because it may be accurate, your understanding, or maybe explainable, both that and your comment that maybe some of the issues that Ms. God noticed before have now been addressed and things are moving forward. So if the state is prepared and wants to respond to what Mr. Thierman just said, either through Mr. Ott, Mr. Jordan, Mr. Whitney, or if you'll allow the administrator to speak directly, I'll certainly welcome any comments you have at this time.
So this is Deputy Attorney General Greg Ott. My understanding is that that functionality that Mr. Thierman just described of automatically shifting an application from one system to another does not exist at this time. I don't want to go into details of yesterday's hearing, because I understand we're here to talk about the scope of the special master, but my understanding is that that functionality does not exist.
All right, so this will be something, if Mr. Guanasso can add this to his plate, if it's happening that way, and if there are other, you know, if that is causing difficulty, untenable delay, inconsistent with DETR's charge here, you know, I'm sure that'll be part of the report, but I'd sure like, you know, people to be paid from one bucket or the other, unless there's a legally viable reason for them not to be. And if I'm convinced that they ought to have been paid and they are not, then that's an issue the court will address on Thursday of next week. On the other hand, I need to know I need more information at this point. All right.
Your Honor.
Yeah, go ahead.
One other thing I forgot that I was just looking at my notes about is you asked the question probably 4 or 5 times yesterday, what are other states doing?
Yes.
And so part of our work will also be looking at other comparable states to see how they're handling similar issues and if they're doing it better or not. Better is kind of a valuative word. I don't mean to suggest that DETR's not doing the best work they can, but there may be other solutions to the problem that are finding some success in other states. And so we'll look at a few states here in the Mountain West, our neighbor, California, Arizona, Utah, Colorado. And then we'll look at some other states that, you know, have appeared to get benefits out to people on what they're doing that may be different than what our state's doing. And I'll include that in the report as well.
Okay, thank you. You know, we all deserve time off. We all deserve to spend time for our physical and mental health and social enjoyment and with our families. But again, we have a self-imposed deadline. And so, you know, dates, time on the clock, weekends, they don't mean anything right now, because I want to make a ruling on this case Thursday, in part based on a report I get from the special master on Wednesday. That doesn't mean people have to work, you know, it just means that let's work really hard to get as much of this information as we can, please. All right. Starting with Mr. Ott, anything else you want to put on the record right now with respect to the duties or responsibilities of the special master? The concerns with applicant confidentiality are noted. The reference to the statute, which memorializes the law on that, is noted. The data dump issues and the extent of data and making sure that there's a way to get that to Mr. Guanasso, or at least portions of it, that possible concern is noted. And the, yeah, anything else you want to put on the record at this time?
No, Your Honor, I think you've gotten all of our issues. So thank you for your attention.
My pleasure. And again, I want to emphasize, if you're at an impasse on any issue that requires judicial intervention, within a few hours, I'll be on a call with you and we'll figure it out. Mr. Thurman, anything else? I
Nothing
thought
further, Your Honor.
I thought I saw your colleague on the phone a little while ago, but
I
apparently
think she's sorting 5,000
emails.
emails.
All right, well,
Mr. Nasso gave us a project to sort them by topic, and we're sorting. And of course, it's it's elbows and
good.
whatever.
Well, I'm glad Mr. Guanasso is working hard already. Mr. Guanasso, anything else?
I have nothing further, Your Honor. Thank you.
All right, thank you. So again, expect an order hopefully by tomorrow afternoon, Friday morning at the latest. Read it. If you believe I missed something, it's incomplete, inconsistent with what we've discussed, or it's totally consistent, but you object. You can file an objection, or we can have a call. Your choice. All right. With that, I think that will conclude the hearing. Unless we do another hearing or call in advance, the next time we see each other will be Thursday morning of next week at 9 o'clock. Looking forward to get Mr. Guanasso's report next filed and distributed next Wednesday. But again, I'm available between now and then on a fairly moment's notice. All right, that will conclude the hearing. I wish everyone a very pleasant afternoon. The court will be in recess.
Thank you, Your Honor.
Thank you.